Today we're examining a federal law that's supposed to protect both abortion clinics and churches equally, but has become a weapon of selective prosecution depending on who's in power. This is the story of the Freedom of Access to Clinic Entrances Act, and how both the Biden and Trump administrations have weaponized it against their political opponents. The Don Lemon case. On January 19, 2026, anti-ICE protesters disrupted a Sunday service at City's Church in St. Paul, Minnesota. They entered the church, chanted ICE out because they had a pastor who allegedly worked for Immigration and Customs Enforcement. The Trump Justice Department immediately threatened charges under the FACE Act. Among those threatened, journalist Don Lemon, who was documenting the protest. Here's what makes this unprecedented. There appears to be no prior case of a reporter being charged under the FACE Act for covering a protest. Journalists have been arrested for trespassing while covering events. But charging a reporter under the FACE Act? That's new. And here's what happened. U.S. Magistrate Judge Douglas Micko refused to sign the complaint against Lemon. He also struck down FACE Act charges against two protesters, writing no probable cause on their arrest warrants. His reasoning? He didn't see any threat or use of force. But the Trump administration didn't give up. On Thursday, January 30th, 2026, Lemon was arrested by federal agents. A grand jury had been impaneled. The exact charges haven't been confirmed yet. But the message is clear. The Trump Justice Department is going after him. What the FACE Act actually says. So what is this law they're using? The Freedom of Access to Clinic Entrances Act was passed in 1994 under President Clinton. It prohibits using force, threat of force, or physical obstruction to interfere with two things: people obtaining reproductive health services and people exercising religious freedom at places of worship. The key language is specific: by force or threat of force, or by physical obstruction. It also explicitly states it does not prohibit peaceful picketing or other peaceful demonstration protected by the First Amendment. Penalties vary. A first-time, nonviolent offense carries up to 6 months in prison. But if you cause bodily injury, it's up to 10 years, and if death results, up to life in prison. The law was passed in response to an escalating campaign of violence against abortion clinics in the early 1990s. Between 1977 and 1993, there were over 6,100 clinic blockades and more than 1,000 violent acts against physicians and patients. This included 41 bombings, 175 arsons, assaults, kidnappings, and death threats. Groups like Operation Rescue organized massive blockades. In one instance, about 1,000 people were arrested in a single day for blocking clinic entrances. The Army of God was particularly violent, responsible for bombing and setting fire to over 100 clinics. They even published a tactical manual for arson, chemical attacks, and bombings. The violence reached its peak in March 1993 when Dr. David Gunn, a physician who performed abortions, was shot and killed outside his clinic in Pensacola, Florida. That same year, Dr. George Tiller was shot and wounded in Kansas. Another Dr. John Britton was murdered in 1994. The law was designed to give federal authorities the power to protect clinics when local law enforcement couldn't or wouldn't. To secure Republican support, the bill added language protecting places of worship too. It passed the Senate 69-30, with 17 Republicans voting for it. President Clinton signed it into law on May 26, 1994. According to the National Abortion Federation, after the FACE Act was enacted and began being enforced, incidents of murder, bombing, and arson at clinics dropped by about 30%. The law appeared to work. That second provision, protecting places of worship, sat mostly dormant for 3 decades, until now. The force element matters. Here's why Judge Micko's ruling is significant. The statute requires force, threat of force, or physical obstruction. It's not violated by merely being disruptive or verbally protesting. When the Justice Department prosecutors argued the protesters committed crimes of violence, Judge Micco shot back. "I don't see any threat or use of force. The protesters entered the church, chanted, confronted people verbally. But did they use force? Did they physically block anyone?" That distinction matters enormously under this law. How the FACE Act has been prosecuted. Let's look at how this law has actually been used. According to data obtained by Texas Republican Representative Chip Roy, between 1994 and 2024, the Justice Department brought 211 FACE Act cases. 205 of them, that's 97%, were against pro-life activists. Under the Biden administration specifically, the DOJ brought 24 FACE Act cases against 55 defendants. Here are some examples. Violent property damage was prosecuted. A man who threw a Molotov cocktail at a Planned Parenthood. Someone who fired BB guns at a clinic 11 different times. People who spray-painted threatening messages on pregnancy centers. But then there were cases involving nonviolent obstruction. Red Rose Rescues are organized pro-life actions inspired by Canadian activist Mary Wagner. Here's how they work. A small team enters an abortion clinic waiting room. They talk to women scheduled for abortions. They offer red roses with cards listing crisis pregnancy center phone numbers. They try to persuade women to choose life, and then they refuse to leave until physically removed by police. Their explicit goal, stated in their mission statement, for as long as they are present and trespassing, no abortions will be performed. In one case in West Bloomfield, Michigan, the clinic director testified that 11 women did not get abortions that day because of the Red Rose Rescue. These protesters didn't use weapons. They didn't make threats. They didn't cause property damage. They didn't physically block doors or hallways. Their code of conduct explicitly prohibits that to avoid FACE Act violations. But prosecutors argued that by entering the facilities and refusing to leave, they obstructed the clinic's operations and prevented women from obtaining abortions. 6 people in Tennessee were convicted of FACE Act violations for this conduct. They face up to 11 years in prison. Paul Vaughn was arrested at gunpoint by the FBI in front of his wife and 11 children. Mark Houck, a Catholic father, had about 15 FBI agents raid his home in front of his 7 children. He was charged with violating the FACE Act for allegedly pushing an abortion clinic escort who was harassing his son. He faced 11 years in prison. He was acquitted. The judge said the law seemed stretched a little thin. But here's where it gets worse. The Biden administration didn't just use the FACE Act. They combined it with conspiracy charges under the Ku Klux Klan Act, a Reconstruction-era statute designed to protect Black Americans' civil rights. This was the first time in history the Klan Act was used against pro-life protesters, and it increased potential sentences from 6 months to over 10 years. One of the people convicted and sentenced to prison, Paulette Harlow, 75 years old. Another, Bevelyn Williams, a young Black mother, sentenced to 41 months. President Trump pardoned 23 of these pro-life activists on January 23, 2025. The first inconsistency. Now let's compare the Red Rose Rescues to the Minnesota church protest. Red Rose Rescues entered abortion clinic, talked to patients and offered roses, remained until physically removed, prevented abortions from being performed. Result: convicted under FACE Act, facing up to 11 years in prison. Minnesota church protest. Entered church during service, chanted, confronted pastor and congregation, disrupted worship. Result: magistrate judge wrote no probable cause. If the Red Rose Rescues constituted criminal physical obstruction just by being present and refusing to leave, then the church protesters did too. If the church protesters didn't use enough force to violate the FACE Act, as the magistrate found, then the Red Rose Rescues shouldn't have been convicted either. You can't have it both ways. Either physical presence that disrupts a protected activity is obstruction under the FACE Act, or it isn't. Were reporters covering Red Rose Rescues? Here's another angle. Were there journalists covering Red Rose Rescues? Yes. LifeSite News reporter Stephen Cox was present at a Red Rose rescue in Grand Rapids, Michigan, in May 2020. He reported on the event. 5 rescuers were arrested. Was Cox charged with anything? No. Comment magazine published a detailed account where a journalist wrote about being inside the clinic, walking through hallways, documenting the protest. Were they charged? No. So we have journalists documenting people entering clinics, disrupting operations, refusing to leave, and they faced no charges. But Don Lemon documents people entering a church, disrupting a service, confronting the pastor, and he's arrested. If being present and documenting a disruptive action makes you a participant rather than a journalist, that standard should apply to all reporters covering all such events, not just the ones whose politics you oppose. Now let's look at the other side of the FACE Act, the provision protecting places of worship. Between 2020 and 2024, there were over 400 documented attacks on Catholic churches. According to the Family Research Council, 436 attacks in 2023 alone. These weren't minor incidents. We're talking about arson attacks, statue destruction, Virgin Mary statues beheaded, hands cut off Christ statues, windows smashed, satanic graffiti, bomb threats, gun threats. Many of these attacks came after the Dobbs decision leaked in May 2022. Groups like Jane's Revenge and Ruth Sent Us claimed responsibility and threatened more violence. The FACE Act explicitly protects places of worship. So how many FACE Act prosecutions did the Biden Justice Department bring to protect Catholic churches? 0. Not a single one. They brought 1 case total for destruction of religious property. Maeve Noda vandalized St. Louis Catholic Church in Bellevue, Washington, in June 2022. Destroyed a $30,000 Italian-made Virgin Mary statue, smashed windows, spray-painted anti-Catholic graffiti. Assaulted a church employee, literally spray-painted their face and clothes, also smashed a police car. The Biden DOJ charged Noda with destruction of religious property, a misdemeanor, not the FACE Act, and they recommended 0 jail time, just 3 years probation. Compare that to 75-year-old Paulette Harlow getting 24 months in prison for participating in a clinic blockade. Attorney General Merrick Garland's excuse for not prosecuting church attacks. They happen at night in the dark, making perpetrators hard to identify, while clinic protests happen during the daylight with photography. But here's the thing, many of these church attacks were captured on security cameras, suspects were identified, and still, no FACE Act prosecutions. So let's lay out what actually happened. For 30 years, from 1994 to 2024, every administration, Clinton, Bush, Obama, Trump's first term, and Biden, enforced the FACE Act the same way, to prosecute people who obstructed abortion clinics. Not a single FACE Act prosecution was brought to protect churches during this entire period, despite hundreds of attacks. The Biden administration continued this historical pattern. They prosecuted people who entered clinics and obstructed access to abortions. They did not use the FACE Act to prosecute attacks on churches, but neither had anyone else in 30 years. Then came Trump's second term. He pardoned 23 people who had been convicted of obstructing abortion clinics. And he became the first president to aggressively pursue FACE Act charges for disrupting a church service, including attempting to charge a journalist who was covering the event. This isn't both sides weaponizing the law. This is one administration enforcing it. But wait, there's a crucial difference. Now, before we conclude that this is all just partisan hypocrisy, there's one critical legal distinction we need to examine, and it might actually justify different outcomes. The FACE Act requires that you act in order to intimidate or intentionally interfere with people exercising their protected rights. Intent matters. Red Rose Rescues have an explicit stated goal: stop abortions from happening. Their mission statement says it clearly: for as long as they are present and trespassing, no abortions will be performed. They measure their success by how many women don't get abortions. Preventing the protected activity, obtaining reproductive services, is the entire point. The Minnesota church protest had a different goal: confront the pastor about his role with ICE and protest deportation enforcement. Their target was the pastor as an ICE official, not the church as a place of worship. They were protesting ICE policy, not trying to prevent worship. Disrupting the service was a side effect, not the objective. This distinction might explain why Magistrate Judge Miko found no probable cause. He may have recognized that these protesters weren't trying to stop worship. They were trying to confront an ICE official who happened to be leading it. Intentionally obstructing a protected activity is a FACE Act violation. Incidentally disrupting a protected activity while pursuing another goal might be trespass or other charges, but not necessarily a FACE Act violation. That's actually a legitimate legal distinction, not just political bias. But here's the problem: that distinction wasn't applied consistently by the Biden administration either. They prosecuted pro-life protesters whose primary goal was to save lives by talking to women, not to physically obstruct the clinic. What we're looking at is the weaponization of federal law enforcement. Both administrations have used the FACE Act as a cudgel against their political opponents while giving their allies a pass. The law says it protects both abortion clinics and places of worship. It says it requires force, threat of force, or physical obstruction, and it says it doesn't prohibit peaceful protest. But in practice, it's been used 97% of the time against one side of the abortion debate. It's been used to put elderly people in prison for obstructing clinic operations while recommending no jail time for someone who destroyed a $30,000 church statue. It's been used against protesters the administration opposes, while attacks against institutions the administration sympathizes with go largely unprosecuted. And now it's being used to arrest a journalist. The fundamental principle of justice is that like cases should be treated alike. When you prosecute people for obstructing clinics, but pardon them while prosecuting people for disrupting churches, you're not enforcing the law. You're enforcing political preferences. When you have 400 attacks on churches with 0 FACE Act prosecutions, but 24 cases against 55 pro-life defendants, you're not protecting freedom of worship. You're protecting your political allies. This isn't justice. This is selective prosecution. And it erodes faith in the entire legal system when people see the rules don't apply equally. The FACE Act was supposed to protect people's rights, both to access reproductive services and to worship freely. Instead, it's become a political weapon. And until both parties commit to enforcing it consistently, based on conduct rather than ideology, it will remain a symbol of everything wrong with our two-tiered justice system. I'm Machine Pun Kelly, and thanks for watching. You'll find a link to a list of source material in the description section. If you learned something, don't forget to hit like and subscribe. And drop a comment about what you think. Is there hypocrisy involved here?